Okay, so ultimately what I'm concerned with here is what a patent, who it's for. And my contention is if you're Martin Shkreli, a patent is your own private ATM, albeit a machine, to which your access is impeded by the indigent, those nasty poor people, and the horrible SEC. If you're the US Special Trade Representative, it's an embodiment of global hegemony, it's an enabler of a manifest destiny in which the actors who command the rules of intellectual property are rewarded with superior returns on investment, economic growth, and a vibrant research industrial complex. So in this presentation, I suggest that we can usefully, just for a moment, step back from the important debates about term extension and TRIPS flexibilities, and instead think about patents as part of an overall information machine. And that machine, ladies and gentlemen, is broken. It needs to be fixed, and surprisingly for me, given I'm a snarly old pessimist, it can actually be fixed. It needs to be fixed in order to facilitate the flourishing of the 99% rather than Piketty's 1%. It needs to be fixed in order to reaffirm the legitimacy of research institutions, entities that are increasingly captured by business partners and coerced by a predatory publishing sector. So my introduction to intellectual property, given that we're talking a bit today about ourselves, my introduction to intellectual property was courtesy of Professor Rimmer, who very kindly didn't throw me out of his seminars, I think a decade ago, more than a decade before I even dreamed of undertaking a law degree. And I also had the privilege of hearing Peter Drahos, whose work about both the rationales for IP and the practicalities, the operation of national patent offices, has resonated over the past 2 decades. So one conclusion I've drawn is that we can usefully understand patents as a manifestation of information rather than merely as property in a market economy that's meant to privilege the global north and entrepreneurs such as Shkreli and the Sackler family, the opioid kids. And that manifestation is part of a broader system. And for want of a better word, a machine that results in the generation, dissemination, validation, and use of information. Ultimately, the legitimacy of that machine is a matter of public goods, a basis of the individual and collective flourishing that's espoused by theorists such as Martha Nussbaum. And the machine extends well beyond exclusive rights in inventions. It encompasses information about prices, important given the significance of private health insurers and state subsidies, such as the PBS in Australia. It encompasses epidemiological information on a forensic or a prospective basis, a foundation for public health systems in which discovery should not be secret, and researchers benefit from the shoulders of past or present giants. That benefit involves the distribution and validation of information. The machine also encompasses restrictions on what are elsewhere dubbed fake health news, something that I think in practice is probably more important than fake political news, sort of thing that we're seeing from Donald Trump and friends. And it's evident, for example, in litigation over harmful claims by wellness guru Bill Gibson and the operators of various Australian cancer cure and anti-vaccination sites. So I'm going to address, hopefully very briefly, specific aspects of the machine and their defects in a moment. But as a starting point, I want to suggest that if we're concerned with patent regimes and with scientific information, we need to engage or re-engage with questions about social license, information dissemination and validation. Much policy making about pharmaceuticals and medical devices appears to construe patents as a self-evident good, viewed for a good that's viewed through the lens of patent holders. Those holders may, of course, be investors who have not, like Mr. Shkreli, who have not materially contributed to research and testing. Shkreli has not been out there with the test tubes and the lab kits. A contrary view is that patents and the overall information machine, in which we provide incentives for the generation and sharing of information, are a matter of social license. And that license is a function of public perceptions of legitimacy, most simply a matter of perceptions of beneficial outcomes and trust in the institutions that shape discourse by identifying and prioritising those outcomes. Civil society, possibly it's a bit surprising given my age, but civil society has some scope to reshape this discourse and potentially revivify gatekeepers such as Australia's Therapeutic Goods Administration, an agency that I'm sorry is not working very well. And questions about scientific information and its dissemination involve thinking about confidentiality. We've heard quite a bit today about secrets. and about the price of access to information in fora such as scholarly journals and conferences, sort of thing that Otlet was interested in. And they also involve thinking about validation. And we can construe validation as a legitimacy provided by recognition in law, for example, recognition of rights under intellectual property law. More deeply, validation is also a matter of verification, scope for the testing of claims through independent scrutiny, and thus the opening of the black boxes that are relied upon by patent holders through, for example, non-disclosure of test data. Now, in the abstract for this presentation, I refer to problems with scholarly publishing, and by extension, the research model at many Australian universities. And those problems are evident in, for example, current controversy in California about the university subscription, and it's a large-scale subscription, to Elsevier publications. They're also evident in the disquieting closeness of some Australian institutions, no one name them, some Australian institutions to complementary product providers such as Blackmores and Swiss. And as a wizened law academic, I hope to be forgiven today for referring to complementary products rather than complementary medicine, particularly given the dubious claims about nutraceuticals, manceuticals, and my favourite, potions featuring the oil of non-domesticated krill. Apparently, wild krill oil is the thing, but if you have your own krill, not quite as good. Now, it's common to construe predatory publishing as a matter of junk publishers such as the notorious Omics, enterprises that deservedly attract the attention of trade practices agencies such as the US Federal Trade Commission. But if we're thinking holistically about information, we should, however, think about access by the Global South. Matthew's highlighted some issues with the South and the North. The Global South to scientific information in high-quality journals from the dominant 4 or 5 publishers. Publishers that enjoy a return on investment that would gratify many investors in big pharma. A succession of Australian and overseas studies has highlighted substantive concerns regarding predatory pricing by the likes of Elsevier and Springer, with annual increases in subscriptions that far outpace the cost of inflation. Subscriptions are increasingly unsustainable for third-tier universities in Australia, again not pointing to any of them, and they're not offset by punitive pricing for one-off access to specific articles. They're definitely out of the question for many institutions in the Global South, and this exacerbates what I would suggest is a soft neocolonialism in the form of researchers migrating to the North. We've heard about Nobel Prize winners and their teams. All right, many researchers will cluster with other researchers. They want leadership. Possibly they want sort of a protege relationship. They'll go where there are opportunities and excitement. That problem's exacerbated by the proliferation of fake books on Amazon, which, whether we recognise it or not, is now the global disseminator of print information. There's a fascinating article about 2 weeks ago in the New York Times doing some number crunching about this. So a classical rationale for patent protection has been the notion of an exchange for secrets. The inventor gets exclusive rights on a justicial basis for a finite period in return for information sharing during the life of the patent thereafter. We sufficiently valorise the presumed public goods attributable to pharmaceutical patents that we grant, and my emphasis is grant, we have some choice here. We grant pharma rights holders that exclusive protection for a period that is substantially longer than grants to patentees of other inventions, including 3D printing devices. Now, given that protection, we could mandate that life science patent holders more fully disclose test data regarding their products, preceding and subsequent to application for the granting of the specific patent. Transparency is, in essence, the price that inventors and investors pay for their limited monopoly. And as Dr. Benithan notes in her presentation, unfortunately you're going to have to hear me again shortly when I present her presentation on her behalf, gatekeepers such as the TGA appear to lack both the in-house skill and, more importantly, the will, the mindset if you like, to gather and publicly share information about the quality and effectiveness of patent-protected pharmaceuticals and medical devices. Their emphasis is on a closed-door consultation with product vendors, alongside a belief that vendors will fully disclose terms on a timely basis. That belief is regrettably misplaced, and from an information perspective, it's disquieting that regulation in the Australian medical device space, for example, is being driven by the ABC, The Guardian, and a handful of academics. Now, that doesn't have to be the case, and it's not antithetical to a coherent national privacy regime. My suggestion is that we need a publicly accessible, comprehensive injury database rather than the paternalism on the part of the TGA. So what about dollars? One of my students, rather cheekily, recently explained intellectual property to me in a few words by saying, "It's about the money, honey." And if we think of money as an expression of information, a manifestation, if you like, of information, we need to know more and then act on that knowledge. In essence, we need more transparency about pricing. That transparency provides a basis for state intervention and for shaping social licence. So, salient research by Morgan, Vogler and Wagner in 2017 explored the significance of discounting of speciality and non-speciality pharmaceuticals purchased through public and private health schemes in 10 high-income markets, including Australia. And the authors comment that, and I'm quoting now, because confidentiality allows for price discrimination across payers, secrecy is integral to those pricing schemes from the perspective of manufacturers. Now, irrespective of any changes to patent law, we need to engage with questions about secrecy and self-interest. And the authors I cited a moment ago note a prisoner's dilemma here. And I'll quote again. "Everyone may be better off if bound to a more transparent pricing model, but given any level of global price transparency, individual institutional purchasers still have an incentive to strike confidential deals if doing so is the only way for payers to obtain lower prices for their health systems. Extracting value in the local health system may therefore trump the benefits of transparency at the global level." My contention is on that basis, it's unsurprising, but of course disappointing, that Australia, along with peers such as Canada, we all love Canada, don't we? Nice people in Canada. Disappointing that Australia and Canada has been resistant in this year's World Health Assembly discussions about opening up the pricing black box in the global public interest, and it's accordingly opposed a draft resolution proposed by Italy, Spain, Uganda, Egypt, Greece, South Africa and Malaysia, among others. It's an interesting coalition there, or an interesting group of actors. Now, that resistance is of particular concern given indications that philanthropic support for access to medicines in the global south appears to be waning. And sorry, Donald Trump won't help. Now, machines that are broken can be thrown away, or they can be fixed. My contention today is that we can fix what I've dubbed the information machine in two fairly practical ways, some of which are a bit unexciting. So, more information, in other words, greater sharing. Regulatory responses to misuse of information, sort of thing that we have with Mr. Shkreli, which is ultimately a matter of a changed public and institutional mindset rather than merely resourcing. So let's start by looking at egregious rent-seeking. I began this presentation with a jibe about the Wall Street Pharma Bro. Regrettably, but unsurprisingly, this is one area of non-specialists I think really haven't got across yet, Shkreli isn't an exception. And we might remember the $100 million settlement by Mallinckrodt after consumers and the US Federal Trade Commission took exception to that blue-chip drug company, so highly respectable, now owned by a German pharmaceutical company. Mallinckrodt imposed an 85,000% increase on one medication. 85,000%. That's a lot of money. Would we regard this outside patent law as gouging? Now, we don't have, regrettably, thinking about information, we don't have a comprehensive resource base that identifies such price increases. Those price increases arguably don't reflect development costs, and we don't have a database that systematically identifies responses by trade practices agencies. My contention is that such information would be useful for shaping community awareness in relation to the social licence that underpins patent law and underpins state or insurer subsidisation of drugs and medical devices. More broadly, it would encourage a change of mindset among agencies and politicians who have experienced regulatory capture by conceiving public good narrowly as a matter of access to medical products through support for the corporations that they regulate. We need to empower agencies such as the FDA and the TGA, a revivification that's a function of both adequate resourcing and, importantly, a revived sense of mission. And this is challenging in the era of Donald Trump. Now, we could start the revival quite practically, quite simply, only a few words, by amending the objects provisions in Australia's Therapeutic Goods Act to ensure that it's interpreted by that agency, by the TGA, as pro-consumer rather than as what functions as an industry support statute. I've suggested that access to information matters. It used to be said that what was good for General Motors was good for America. In 2020, what's good for Shkreli, Merck, Pfizer, Novartis, Ranbaxy, Sun and Hoffmann La Roche may not be good for the people of Indonesia, Australia or the United States, irrespective of an individual's health and capacity to pay. So we need to look at the effectiveness of the Doha flexibilities and more effectively critique the willingness of states such as Australia to sign up to TRIPS Plus mechanisms such as the Trans-Pacific Partnership Agreement. We might ask, for example, why policymakers in Vietnam aren't using the Doha flexibilities. And arguably, I'm working with a PhD student on this at the moment, arguably it's as much a matter of mindset as it is of the Vietnamese government's anxiety about US special watch listing. We could realign the research industrial complex, recognising the significance of public funding. Possibly we could echo the Bayh-Dole scheme with a clearer, more comprehensive disclosure regime. Put it crudely, if you stand on the shoulders of giants, particularly stand on the shoulders of public institutions, you should be prepared to share. And if you're a university or the NHMRC, you should reward open access, something that is not synonymous with rewarding Hindawi or omics. We need to, nearly done. We need to overcome Australia's democratic deficit by paying less attention to Clive Palmer's Titanic and more attention to proposals for delinking incentives for R&D from the patent system and determining the selection of health products on the basis of evidence rather than rewards to prescribers. So I'm just going to wrap up now very quickly. Famous case, some of you, I hope, if not all of you, will be familiar. Apotex and Sanofi and Aventis, Chief Justice Robert French, in that High Court judgment in 2013, commented, okay, there are problems here. Quoting, the field of intellectual property law generally is notoriously one in which there are public interest and private interest in fierce competition with each other. A public interest may lie in using the grant of monopoly to encourage technical innovation. A competing public interest may lie in ensuring unconstrained access by medical practitioners and their patients to new medical processes and new medical methods and processes. The interests of inventors and investors in inventions and interests of members of the public whose lives could be improved or saved by use of innovative medical treatments may be in tension with each other and with aspects of the public interest. There's room for debate. I think this is sort of the debate we're having today. There's room for debate about whether the law does or should reflect proprietarianism as quote, the dominant normative influence, or whether it should be seen as instrumental in support of publicly beneficial goods. So in building on today's presentations by Benathan and Tess Watson, my conclusion is that we need to face the challenge of thinking about whether policy about information, rather than simply about patents, is a matter of proprietarianism and private power, or what Chief Justice French, in citing Peter Drahos, characterised as publicly beneficial goals.